All right, here we go. Hi, everyone. This is Kurt Varone,
And Brad Pinsky.
and we're here for another edition of Fire Law Roundup, this time for July 22nd of 2024, but we're recording it on the 21st.
Because we know you wanted it early.
And Brad has someplace to go.
And that too. I got to be in court. Got to be in court. What can you do? Okay, so we are going to start off with, again, what is just so disappointing to see. A St. Louis firefighter is now admitted to stealing a patient's wallet. And I read this. I'm like, are we back at the FDNY? We just had this case where he was set up. Here we go again. We have another one. He said I got to check the patient's ID. But if you don't think you're going to get caught on camera or you're going to get caught when you're making the purchases with the credit cards, you're nuts. And what happens? He gets caught on camera, right? I think the police caught him on the body cam. What are we doing, people? If you are in the fire EMS service and you are a crook, you're dumber than God. I'm sorry. I don't even know what that means. Dumber than
I
God's
don't think
whatever.
people don't think of themselves as crooks, though. They rationalize it as, you know
Oh,
what, I'm working real hard, and they have a whole rationalization that they convince themselves that it's okay. I'm just going to
I,
do it this one time. And sometimes there's drugs involved, sometimes there's gambling involved, sometimes there's other things, but they don't, like, nobody says, "Oh, I'm a crook."
and
They
you
always
don't
have
think they're
some.
crooks? I mean,
Well, you and I would agree, but I
oh, it
think
kills
got
me. And
somebody down.
it kills me because the damage they do to the fire service, the emergency service, to the police, right? I
I
mean, the reputation, it's never, right? It's never, oh, John Doe stole. It's always a firefighter stole. And here you go. I
And
mean,
it
just,
reflects on all of us, absolutely. But
right. I
again,
mean,
that's the least of their concerns. And
yeah,
I've had to deal with a few of these over the years, and it's unfortunate, but
you
it is
know,
what it is. But I think
yeah.
it's kind of interesting. They apparently, when they charged him, I guess they didn't feel like they could prove that he stole. And I would have thought they could have, but they didn't charge him with stealing the wallet. They
Just
charged
using the
him with
card.
receiving stolen property, which is kind of a way of basically saying we can't prove that you did take it from the scene, but we
But you
saw
have it now.
you later turned up with it and tried to use
Yeah.
it, and then fraudulent use of credit cards. So I'm assuming part of that plea deal is they're not going to charge him with those other offenses, which arguably they could, particularly given the fact that he admitted to stealing it. So now the question is going to be, is he going to jail, number one? And there was some discussion in the news media about whether or not he's going to go to jail. And then obviously, if he goes to jail, he's not going to be able to keep his job, but is he going to be able to keep the job? So,
It's disappointing. And I know people like that don't care about the fire service. They don't care about our reputation. So it's not a,
well,
preaching to the choir maybe,
yeah,
but
we had a guy like that, and he was doing it like daily.
yeah,
And yeah, I know it was really sad, but it was drugs. You know what I mean? It was drugs. And
yeah,
and,
I
and
get
I
it.
don't know, I'm not saying this guy, I'm just saying, I know other instances where it's been gambling, and you know, it's a bad situation.
Look, we know that bad times make good people do bad things.
Yeah.
But listen, not that I'm the best chaplain here, but if you're a viewer and you are in a crisis situation and you have a gambling problem, drinking problem, drug problem, I swear, go to your chief, go to somebody in your department, go to your chaplain, go to whatever. Stealing is not going to make it better, right? I mean, I
Right.
guess you've hit rock bottom when you got caught, but people will help you. I mean, there is a way
Bend over
out. People will
backwards to
help
help you.
you.
Bend over backwards to help you. But
Exactly. That's what
gotta
the
love
fire
what
and
you do.
emergency services is about, not stealing. It's about helping. Okay. Well, let's go to Savannah. Um,
Things
so
get much better in Savannah.
yeah, yeah. Well, this is one of those, this is a tough case, but like Kurt and I always do, we'll make it, we'll kind of make it simpler and understandable, digestible, better word. So we've got a Savannah battalion chief. He's demoted to captain, allegedly, he says, because he complained about race discrimination. So, and you could read this. Look, this is one side mostly, but what he's saying, and I'm not trying to, I view this a little skeptically, but I'm not trying to, come down on his case. But there's a African American fire chief now who's been appointed, right, for most of the last 2 decades. Decades. So we have an African American who's got the highest job title in the department. But what the complainant says is that 17 of 19 upper management positions are held by white males. Now, in fairness, you could say, okay, well, are they white Catholic males? Maybe there's a race issue, a religion issue, there's a gender issue, right? But we're missing some information too, because we don't know how many African Americans are in the department. But you've got an African American chief, so I'm saying he's got a very uphill battle. Now, what happens here is he claims he was trying to advance, right, up the ladder. He was denied, he claims, because he claims there's a racial quota, that there's one assistant chief slot reserved for an African American and the other reserved for a white male. Now, if that was true, you'd have, we're going back to the Frank Ricci thing. We've got discrimination on both sides, reverse discrimination. You can't do that if that's true. I'm not suggesting it is or isn't. In any event, he says he complains about it, etc. And all of a sudden, and I'm going to his language, all of a sudden he says he's notified by the Internal Affairs Department that he's under investigation for violating operating procedures, which directs, and I like this policy, or it's a policy more than a procedure, but won't get off that tangent. So he says you cannot criticize the policies of other officials in the department in the presence of subordinates. I happen to agree with that, right? This is Tom Hanks in Saving Private Ryan, right? When they're walking on the trail and he says, I don't complain down, I complain up. Right? You can complain to me, but I don't complain to you, and I complain up. So that's really this. So I happen to agree. If it's true, we don't know what's true. This is just a complaint, right? Nothing I'm saying we know is true. In any event, so he's then demoted to captain ultimately for a range of these and other things, and he's and that's what it is. So the agency says we're demoting you because you're doing this. He says this is retaliation because I raised the issue. He says I'm being demoted only because I raised the issue. This is almost the same story as we hear a lot, except that, again, he's uphill. We have an African-American chief, not for 1 year or 2 days, decades.
Mm-hmm. Let's talk about the First Amendment implications, though, of that provision there that seems to restrict speech, but it has that caveat. It's not that you can't complain. It's just that you can't complain in the presence of subordinates.
Right.
Now,
his complaint was about his job. So he's speaking, in my view, he's speaking as an employee, right? If you're going to address it to him, as applied to him, I think he's speaking as an employee because basically he's saying, I can't get promoted. At least that's how I would interpret it. Court may not agree, right? But I agree that policy, it's not saying you can't have speech. It's just there's an appropriate time for appropriate speech.
Mm-hmm. Well, if that policy is in place, and let's say I'm a captain and I'm not happy with something that the chief's doing, and I put something in social media, isn't that in the presence of subordinates who may see my critical speech? And now are we starting to sort of I don't know. I think it kind of comes close. It makes the hair on the back of my First Amendment neck stand up.
I had a different take, not the First Amendment, but how about you can't prohibit two employees from speaking about employer issues?
Well, and there's your concerted activities. Georgia isn't really a bastion for collective bargaining.
Okay, so yeah, maybe they get away with it.
But I certainly in New York or Rhode Island, we've got to deal with the concerted activities, and I think that would run afoul of concerted activities. But again, I'm not sure of the specifics. I know there are some departments in Georgia that have varying levels on a local level of collective bargaining. So,
yeah. I don't know. We'll find out. Anyway, he's looking for to be reinstated. I think he's got a tough road to hoe.
I think he does. And I know several of the past chiefs. I don't know the current chief, but I know several of the past chiefs from Savannah. And the fact that he's actually sued the current chief for
Yeah.
race discrimination, kind of, but on the other hand,
Like
it
that,
is.
they call it an Uncle Tom situation, right? Which I've never
Well,
understood, but that's
I
what they.
guess, yeah, I guess, but you've got this the potential for a retaliation claim. So the fact that I complained about it and now you're retaliating against me for complaining about it, if it was protected speech, you're not supposed to retaliate against me. But I think
If
there
that's
was
what they're retaliating against him for, right? They
right.
claim we have other
Well,
independent
I'm
things.
sure they are. The fact that they sent him for EAP or they offered him EAP and they recommended some additional counseling, may sort of tip the hand as to what their concerns were. Now, whether they were wrong about it or whether they were using that as they were weaponizing EAP,
Right.
that's another issue.
Who knows? But I got to tell you, the lawyer, whoever came up with send him to EAP, and I didn't cover that in the facts, but brilliant, right?
Mhm.
Brilliant, because it looks like, hey, we're really concerned for you here. We want you to survive in the agency. We're trying to, and they didn't terminate him; they demoted him,
Right.
right? I mean, so they could have done worse, I suppose.
Mhm.
Anyway, okay. Let's move on. I love this next one because I started jumping to a conclusion and realized I'm off base. So as I start reading this, we're in Denver. We've got a firefighter who's in the fire academy. And now some of you legal eagles are going to do the same thing I did, maybe jump to a quick conclusion. Anyway, he's suing because, and let me give the rough outline first before we get really specific, but he's suing. He claims that he was required to work more than 40 hours a week, right, while at the academy by having to study. And my first thing is, okay, wait a minute, 40 hours? Who has a 40-hour rule? They got to have more than that. In fact, they do, right? They have 50, I think they're the 53, or yeah, they're 53 hours a week. So he's off by 13 hours, I think, anyway.
Well, not, but we'll get into that. Not quite. Not
And
quite.
but what I find, I'll turn this back over to you. What I find is the most interesting facts about this is not that he was required to study. We actually covered that same issue last week or maybe 2 weeks ago. It's that the material he was studying was actually learning, he claims. It's a novel argument. I thought it was a very interesting argument. He says, we are required to study and have study groups and read material that's not covered in class. It's new material. So maybe he's trying to say this is not studied, this is classroom activity that's going late, and we're required to do all this, so we should be getting paid overtime. Over to you, Kurt.
Well, he's got a point if he can prove his case, okay? Now, the 53-hour a week or 212 hours in a 28-day work period, that's called the 207K exemption or shorthand 7K exemption. In order to this is going to I hate even saying it because it's going to sound like lawyerish crap, okay?
Yeah.
But in order to qualify for the 207K exemption, you have to meet the definition of an employee in fire protection activities, which is in section 203Y. It's the famous 203Y definition. And the 203Y definition has four components. And the first one is you have to be trained. Well, if you're already trained, what are you doing in the academy?
Right.
That's sort of number one. Second of all, you've got to have responsibility to respond to fires. Well, hopefully on the first day of the academy, you don't have responsibility because you're not trained.
Right.
Okay.
Right.
So I think there's some, and I don't want to go into all four of the sort of elements of that. But just because you are a firefighter or you're a recruit firefighter does not mean you qualify for the 207K exemption. And usually the first few weeks, if not most of a fire academy, you're not going to qualify for 207K. There may be a point later on,
Right.
at some point
However,
late in the academy where you do.
right. However, let's go to the COVID case, right? Where we
Yeah,
saw they claimed, well, wait a minute, we had a quarantine. I thought they have a case
yeah,
where they claim, well, we had a quarantine while at the academy and we couldn't leave. It wasn't our own time. And
yeah.
so they claim they should be paid overtime for that. This is kind of like that, where we're saying it's not the normal training. The general rule, right? Correct me if I'm wrong. The general rule is when you're at the academy, just because you're required to study, you're not getting paid overtime for that. It's
Well,
just study time.
Study time is compensable. Now let me just, yeah, there's actually cases on it and there's opinion letters on it. And so we go through this in the class. Study time is compensable, but here's study time. You are studying knots, okay? And you're not doing well in knots. Or maybe it's your SCBA. Maybe you're not putting your SCBA on quick enough or your PPE quick enough. And you practice during the day, and then comes 4 o'clock, class is over, and the instructor pulls you aside and says, you better be able to put on your turnouts in 60 seconds tomorrow. Take your gear home. I want you to practice. That's compensable. Okay. Now, you got an exam tomorrow. Be prepared. That's not compensable.
Okay, that's where my understanding always
exactly.
was. You got to study for.
Notice the nuance.
Yep.
Okay.
But I think he's pegged it.
Well,
if what he's saying is true, he's kind
here's
of
the lesson. Here's the lesson for the folks who are running our fire academies. Be very careful what your instructors tell your students, because if you tell them exam tomorrow, no problem. If you say you better put in 8 hours of studying tonight, and you better get it done, and you better be able to do it, or you better be able to tie those knots, or you better be able to get your turnout gear on in the designated time, and bring it home and practice. When you tell someone to work at home, it's compensable. So our instructors have got to be alert to that, and a well-intentioned instructor could create that kind of a problem. So bottom line is, when study time is mandatory, it is compensable. When it's just to improve your chances of getting a good grade, it's not.
And I think that's what they're doing here by him. I think it's a novel way of saying it was not material covered in class. They're expected to know it. So there's no other way. It's like saying you better know the material, and we're not going to teach it to you, so you go learn it on your own. Now it's not even studying, it's learning, which again puts them back right square. So if that's true, I think, he's got a pretty interesting argument.
Yeah, no, he does. And when I looked at the timing of the whole thing, I thought it was interesting that it looks like he waited till he was off probation to bring the suit.
He's got 2 years, right?
And
it's not fraud. It's probably, this is so slight.
No.
It's not fraud, but he's got 2 years to do it. So why not?
Yeah.
I don't know that I would have been, as a new person, I don't know that I'd be so bold as to sue my employer. I think leaves a permanent mark on you.
One of his officers told him, and that's actually found its way into the lawsuit. And that was probably good advice, that the officer who told him said, "Kid, really, you don't want to have your name associated with this as a brand new firefighter."
Right.
That found its way into the lawsuit. So.
Okay, let's go to, this is really interesting. It's short, it's easy, but it's really interesting. Dallas Fire and Rescue is now being sued because allegedly somebody came in, gave a course, the material was on a computer, on a protected computer, and the material was spread everywhere, and hundreds of people are using this allegedly protected material. And so they're suing for copyright infringement as well as some other things. My question is really to the instructor. What did, it is very difficult to copyright lessons that you're publicly delivering. You are teaching, right, with the intent that they retain and apply the knowledge. So I have a hard time as an instructor like you, right? We teach all over constantly, all over the nations and North America. And how do you say, look, I know you can, but how do you say my material is copyrighted when you're giving it out for people to learn? Now, I don't know, is he giving lesson plans? Is he giving summary? But people are supposed to take notes, or you're supposed to infringe, right? It's learning. So I'm a little confused whether they'll succeed or not. What about this material was not supposed to be given and retained and passed around? And his argument might be, I couldn't totally tell, might be, well, wait a minute, I taught the students, but the students have, given everybody else the material. Now that I could possibly see. It's like saying I gave you the lesson book, you bought it, but then you copied it and gave it to everybody else. That would be
I think
problematic.
that's what it is. Now, it wasn't a lesson book. It was actually a series of videos that trained EMS personnel. So it was like basically a training program that he sold. And I'm not sure, it's not clear to me whether or not he sold it. I don't know. I read the complaint
It's
several
tough
times
to,
and it was
yeah.
hard to piece together, but I'm not sure whether one of the named defendants took it from someone who it was sold to, or whether or not it was sold to Dallas Fire and then they allowed it to be copied. So I'm not 100% certain there, but I think that the nuts and bolts of it are that there was a curriculum that he developed that was a video training program. And apparently it was pretty successful in getting people to pass some of the certification classes. And somebody made some illegal copies of it and shared it inappropriately.
And
So,
that clearly would be a problem. You can't
yeah,
copy someone's video, right?
right,
If that's what it is, you clearly can't. It's like copying a book. You can't,
right.
right? You can't
No,
do that.
and
But
certainly when you and I are lecturing and somebody's taking notes, yeah, that's you. That is really what the essence of training is. But if somebody's sitting there without us knowing it, filming us,
videoing,
right? Or we are, for example, and I have done this for a number of departments where I do a customized class for them and I give them a license to use it in-house. They can use it in-house so that when the need happens that they need to refresh someone on maybe like social media,
yeah.
um, they can sit them in a room and say, all right, you got to watch this for 3 hours and we're going to give you a quiz afterwards. And then you've got the person back on the straight and narrow. And, but certainly there's a license there. And if it was to be shared outside of that license, that one of the allegations, in addition to breach of contract, would be a copyright infringement.
Right. And I think there's different, when somebody pays to come to like my conference or they pay to go to your class,
Mhm.
people have asked, like, can I record it? And I said, no, you can record 30 seconds, but I get to see what you do because I don't want somebody taking 30 seconds and taking out of context something I said, or I'm giving an example, or a lot of times I'm like, okay, don't be this guy. And I act out this guy. Right. And so I'm like, well, I don't want someone to be like, that's me. So I've normally said, no videoing,
Mhm.
but it's one thing if it's a paid class that somebody pays to attend. That's how you make your living. And to copy that, to send that out, to send the promotional material or the actual material out, that would be copyright. But if you're
Yeah.
at like an FDIC or a firehouse and you're
Oh,
lecturing
sure.
there,
Yeah. Yeah, and
no.
and really they actually make us give them the rights to the whatever is
Yeah, that
happening.
blew
But
up in
I'm
their
going to tell
face.
you another thing that you know, I never really thought much about until COVID and I started doing webinars, because I never allowed recording in my classes, like a live class. And
I know.
here's why. There's a reason why. We're not that, it's not only about money, but people who have maybe they're in a legal problem and they have a question, they have a legitimate question that is relevant to what we're talking about. If they know it's going to be recorded and that it could be shared with other people, they're not going to want to ask it.
I would say half the things I would say in my class if it was going to be recorded.
Right. And so to me, it's really about academic freedom. And
Right.
that people in a classroom should be free to make mistakes. They should be free to say, I did this, or what about that?
Or
And not
challenge opinions,
right,
right? We
right,
might say, wait a minute, what about this side? We may not agree with it like we do
right.
here, but we always give the opposite side.
Well, imagine you're arguing point A, and then maybe in a couple of years, you're arguing point A in a classroom, right? And then in a
Yeah.
couple of years, you're arguing point B, and somebody's going to flip up a video of you
Hey,
arguing
didn't you
point
say
A in
this?
the class. Are you the same guy that was arguing this?
Yeah.
And so it can limit what people are willing to talk about. And in an academic environment, that is not healthy. That is not good for anyone to feel like that. So I do record some of my online stuff, but I only keep the recordings for 72 hours and I get rid of them because I don't want people not to interact. And the concern is that people won't interact if they know they're going to be recorded.
Right.
So,
Okay, let's do our last one. Last one. This is now unlike everything else, which was pretty much a accusation, a complaint, a lawsuit, now we have actually the appellate division, which is probably the second highest level court in New Jersey, has ordered the reinstatement of a recruit. And they got it right, in my opinion. So this recruit, first of all, had already passed Firefighter 1 separately, been a volunteer, etc. He goes to the fire academy. The allegations were, although I think the court clearly agreed, but that's not what the holding is. I'll get there in a second. But the allegations were that he's being picked on because of his weight. And it sounds like he was being set up to fail on a number of things and accused of things. You're sleeping in class, they accused him of, right? And different, so you refused to shave, you refuse. So they're accusing him of a lot of things. Now, we don't know the facts, but here's the point. They brought in an administrative law judge. The law judge reviews everything and independently concludes he should be reinstated. He was being picked on. They talked to other people in the class who came and testified who agreed he wasn't doing these things. He wasn't sleeping. He wasn't, he was clean shaven. He was able to do the skills. There were exercise issues. He was accused, oh, you can't do enough sit-ups or push-ups. And then somebody else came in and said, no, you just weren't counting them properly. So they bring in an administrative law judge, which is not a judge. It's not like in Article 3, an actual judge, may not even be a lawyer sometimes, but nonetheless, the judge found that he should be reinstated. He was being picked on, and they sided, right? The administrative law judge sided with the firefighter, and all the court does is said, we are not going to look at this de novo of new. We're going to look at this as, was the administrative law judge, did he have a reason for his decisions? A very low standard, and the courts do not want to substitute their opinion for that of an administrative law judge. I'll complain about that separately in a minute. But here, the ALJ made findings, and the court says we are not disturbing them. And that is basic administrative law. I will suggest that I can't stand administrative law, and I live my life in administrative agencies as well as the court system. I'm in the, defending EMTs and ambulance companies in front of the Department of Health and Medicare and Medicaid and Division of Human Rights all the time and what happens is you get an administrative law judge, a lot of times who's not an attorney, definitely not a practicing attorney, and there's no rules of evidence, and the burden of proof is so low, you just need 1% of the evidence, it doesn't matter, well, I have a better case than you, that doesn't matter, that's not the test in administrative agencies, and it's just whoever brings the emotion out to the judge more. And that really is the goal. Who made a more emotional case to the judge? So I'm not saying they get it wrong all the time or right all the time, but it's much easier to be in an administrative hearing than a real court because hearsay is allowed, right? Oh, I talked to Kurt the other day and Kurt admitted that they were doing push-ups wrong. Well, where the hell's Kurt? He's not in court, right? But in court, that would never be allowed. In an administrative hearing, it's all allowed. So it's, you never really want to be in an administrative hearing if you can avoid it and you think you have a bad case. But in any event, here the judges just say, we're not going to overturn the judge. Or the administrative law judge. And a lot of times what the attorneys do, what I'm trying to do is convince the judge, look, this ALJ got it wrong. And there are things you could do. I have this week, I'm arguing that there was triple hearsay and double hearsay. Well, hearsay is allowed, right? Kurt said this, but double or triple hearsay is when Kurt says, Kurt doesn't testify. Somebody says, well, Kurt said that John said, and that's triple or double or whatever hearsay, and that shouldn't be admissible in any event. That happens all the time. You can make that argument in front of a judge, but other than trying to say their process was wrong or so abusive, you're not overturning administrative law judges a lot, and this is just a good example of it.
Yeah, I think what you can start doing, and you can be effective at if you can find multiple examples of violations, whether it's hearsay or admitting irrelevant evidence or considering things that shouldn't be considered, but you can start to show that, yes, you can permit some hearsay evidence, but when things get so out of hand, it's nothing short of a kangaroo court. What you in essence have is a kangaroo court. Now you're to the level of a due process violation. So,
and I can tell you, I have that all the time. I get in the Department of Health in New York State, they bring in an investigator. right? And the investigator testifies, I talked to this person and that person said,
No.
wait a minute, right? Double hearsay. You can't do
Yeah,
that.
and your right to confront adverse witnesses, you're being denied that right. So,
Right.
I when I read this, and I actually I was gonna do another couple of paragraphs on this one point because I wasn't 100% sure what the city's argument here is. But if you look in the quoted language, they're talking about the arbitrary and capricious standard. In other words, that
Right.
the reviewing court, in order for the reviewing court to overturn the Civil Service Commission, they would have to show that there was an arbitrary and capricious decision to rule in favor of this individual employee. And that's a high deferential standard.
Yep.
And what I sense the city was arguing is, think about it. We've got an initial decision to wash this kid out of the fire academy. Okay. And that the ALJ should have been applying that standard to the fire department's decision. Okay.
Mhm.
And now they're arguing that that's the standard that the court should apply to the Civil Service Commission. And should you be using that? Should the ALJ have been deferential to the city? Or was it only when the court is reviewing the Civil Service Commission? But I just kind of felt like it'd be too confusing to get into that. And it wasn't clear to me exactly who was arguing what. I know the court was looking at whether or not the Civil Service Commission was arbitrary and capricious in upholding the ALJ's decision.
Right.
So
And listen, we
I'm
didn't
giving
cover it.
myself a headache. I'm giving myself a headache.
Yeah, I just, as you know, I just won a case in Buffalo, New York, 2 weeks ago. Great written decision. It was fun to read it, but we didn't cover it here. But where the agency had an administrative law judge render an opinion, and they didn't follow the administrative law judge's recommendation. They went a different way. I sued saying they had no reason not to follow the ALJ's decision. I liked the decision, supported my clients, and the judge held it was arbitrary and capricious not to follow the ALJ's decision. There's a little more to it, but effectively, she said you had no reason not to follow it, and they didn't state it in the record. They just vote no, we're not going to follow it. So
No,
there you
no
really
written
lose.
explanation for why they went against it.
Nothing, not a thing. And so the judge said, you know what?
Acts
The
of
ALJ was
arbitrariness.
right. You lose.
Right.
Right. So even when it's your own agency's ALJ not following it, ALJs have so much weight. I want people to understand. And I have the same discussion. We'll end here, but I have the same discussion with my clients all the time who I represent in front of the agency. I said, listen, this ALJ's it. It is going to be very tough to get them reversed. And again, we got no rules of evidence. So if that's in your favor, great. But usually that's not in your favor.
Mass Civil Service does a really good job. They have ALJs, and then that decision is either confirmed by the whole Civil Service Commission or not, but they give a written decision. And I mean, they do a really good job. It's a good model for anybody who's looking for good examples of how to write up an administrative decision to sustain or to overrule whatever an ALJ decides. Yeah, it's good. So.
Well, that is our exciting week for the week.
Unfortunately, this week, I think there was so many interesting cases that we could do another class. Honest to God, with just the cases I couldn't get. We had a couple of firefighters terminated for Trump-related conversations in social media. There was just a number of cases that there was only so many that we could get to this week, but there's always next week. So.
Absolutely. One thing we know is there will always be more cases.
Well, good luck in court tomorrow.
Thank you.
Yep. And we'll see everyone again next week for another edition of File.